Hi everyone, I'm going to go ahead and get started and respect your lunch hour. My name is Melissa Starry. I am an attorney at Holland & Hart, and today is our third webinar in the fraud and abuse series that we've been doing. If you've been participating in them all, you had the Stark webinar a couple weeks ago by the esteemed Mr. Stanger. And then last week was a primer on the anti-kickback statute by my colleague Chris Esseltine. And then next week, on January 29th, is responding to noncompliance and repayments by Kelly McIntosh. But today, we're going to talk about the civil monetary penalties law. Just a quick overview of what we're going to cover today. The civil monetary penalties law, the prohibitions, penalties, and exceptions contained therein. We're going to apply the civil monetary penalties law to common situations, and we'll talk about responding to potential civil monetary penalty law problems. Then at the end, we'll go over some action items, and if there's any time for questions, we can take questions then. Preliminaries. You should have been provided with some written materials. If you didn't, we'll get them to you afterwards. The PowerPoint slides, of course, a copy of the civil monetary penalty law itself, a copy of the OIG Supplemental Compliance Program Guidance for Hospitals. Now, it applies only to hospitals, but it is a good summary of the civil monetary penalties law and how it applies to all healthcare providers, so that's why we included it here. An article by Kim Stanger that summarizes healthcare transactions. So everything that you've talked about in the past few weeks is covered by his article. And then just a quick client alert on the proposed rule that was issued by the OIG in October that revises the anti-kickback safe harbors and the civil monetary penalty rules for beneficiary inducements and gain sharing, and I'll just touch on that briefly. This presentation will be recorded and available for download at the website that you see on your screen. And you can use those presentations for internal trainings if you need to. So that's something that I know a lot of clients have found very helpful. And then if you have any questions, please submit them using the chat line or email me at mmstarry@hollandhart.com. We might not get to the questions during the presentation, so go ahead and submit them to the chat line or to my email address, and I'll get to them afterwards and send out an email. Additional preliminaries that us lawyers always have to have. This program provides an overview of the relevant law. I'm going to get into some of the nuts and bolts, but mostly it's sort of a 30,000-foot view. As always, as we always suggest, read the law, read the regulations, check advisory opinions, or consult with a qualified expert when you are applying the laws to the facts. There's really no substitute for cracking the books here. It's good to just sort of get in the weeds and look at the technical requirements of these regulations and sort of do a checklist as you're going through them. And then always consider other applicable laws, because the civil monetary penalties law does not exist on an island. It works in concert with other laws, for example, the Ethics and Patient Referrals Act, or STARK, which you talked about a few weeks ago, the anti-kickback statute, which was addressed last week, and then always think about state laws, because there might be state laws that affect the issues as well, and then managed care contracts. If you are dealing with private contracts, you need to look and make sure that some of the things that you're doing do not violate those contracts. Finally, this program does not establish an attorney-client relationship, and this program does not constitute the giving of legal advice. But you can go ahead and call us for that legal advice if you so choose. So here we go. Let's get into it. The civil monetary penalties law. That's where it's codified in the United States Code. And unlike Stark and the anti-kickback statute, the civil monetary penalties law is a law that allows the OIG to impose penalties for a wide range of specified conduct. So it prohibits certain specified conduct, this conduct being submitting false or fraudulent claims or misrepresenting facts relevant to services, offering inducements to program beneficiaries, offering inducements to physicians to limit services, submitting claims for services ordered by or contracting with an excluded entity, failing to report and repay an overpayment, and then failing to grant the government timely access. The penalties will depend on the specific conduct involved, and we'll talk about all of these. So in addition to the statute, you've also got to be aware of the regulations. So the implementing regulations are found at 42 CFR 1001.1301. The exclusion regs you're going to find at 1001 and 1002, and then the civil monetary penalties you will find at 1003. The regulations establish the basis for action, the penalties, and then the administrative process for penalties. So the process for defending yourself if you ever get tagged with one of these is laid out in the regulations. So again, review both the statute and regulations when you're applying the laws. So let's talk about those fraudulent activities. There's a whole series of provisions in the civil monetary penalty laws that deal with false or fraudulent claims. You cannot knowingly present or cause to be presented to a federal or state program a claim that is for an item or service that the person knows was not provided as claimed, for example, upcoding. If that claim is false or fraudulent, if that claim is presented as a physician service or a physician extender service, but the person who presented the claim knew that the physician was not licensed, the physician's license was improperly obtained, or the physician misrepresented that he or she was board certified. For a pattern of items or services that a person knows or should have known are not medically necessary is another prohibition. So if you're providing medically unnecessary services out there and billing the government, you can get hit up for the civil monetary penalties. So what are the penalties? At the very least, denial of payment, the very least. In addition, you can get tagged with penalties for $10,000 for each item or service claimed. In addition, you could also get hit up with treble damages, so 3 times the amount claimed for the item or service. And you could also be excluded from Medicare and Medicaid. Now, that's all under the civil monetary penalty statute, but it's not an island. It may also trigger a False Claims Act cause of action. If you're submitting false claims to the government, you can get hit up with a separate cause of action by the government under the False Claims Act with separate penalties. And those penalties are $5,500 to $1,000 per false claim, 3 times the amount claimed, and then repayments of the amounts improperly paid. Okay, so here we go. You cannot knowingly make, use, or these are additional penalties on top of those other penalties. You cannot knowingly make, use, or cause to be made or use a false record or statement material to a false or fraudulent claim for payment for items and services furnished under a federal health care program. The penalty for that is $50,000 per each false statement or misrepresentation, treble damages, denial of payment, repayment of amounts improperly paid, and exclusion. In addition, you could get hit up with additional penalties if you have a false certification for home health services. A physician cannot execute a document representing that the patient meets the requirements for home health services if the physician knows that all of the requirements are not met. Penalty for this, $5,000, potentially treble damages. Additional damages. You cannot knowingly make or cause to be made a false statement, omission, or misrepresentation in any application, bid, or contract to participate in a federal health care program. And that's $50,000 for each false statement or misrepresentation and treble damages. You cannot knowingly present or cause to be presented to any person a request for payment that violates assignment limitations, arrangement with a state agency not to charge a person for an item or service over an allowed charge, or if it violates an agreement to be a participating provider. Additional penalties, $10,000 per item or service, treble damages, repayments of amounts paid, exclusion. False information regarding discharge. Cannot knowingly give or cause to be given to any person with respect to Medicare inpatient coverage information that he or she knows or should know is false or misleading, and that could reasonably be expected to influence the decision when to discharge such person or another individual from the hospital. And you can see the penalties there. So the bottom line is you need to be honest when you're dealing with the government. So you talked about the anti-kickback statute last week. I'll just do a quick little overview here. You cannot offer, solicit, review, or pay remuneration to induce or reward referrals for items or services payable by federal health care programs unless you fit within a safe harbor, and that's a criminal statute. So why are we talking about this again? Because an anti-kickback statute violation is also a civil monetary penalties violation, and there are more penalties on top of your anti-kickback statute penalties. So $50,000 per violation, treble damages, repayment, exclusion again. The good thing is, if you structure your deal to fit within an anti-kickback safe harbor, guess what? You also comply with the civil monetary penalties law. So there is no anti-kickback statute or civil monetary penalties violation if you fit it within one of those anti-kickback statute safe harbors that you talked about last week. And you can see the list there, but the key here is to satisfy all of the technical requirements in order to get the benefit of that safe harbor. So I'm sure you went through and did your homework and looked at all these safe harbors last week after the program, and you saw that there are a bunch of technical requirements. So in order to protect you from the civil monetary penalties law, you're going to have to hit each one of those technical requirements. In addition to the anti-kickback statute, there are separate provisions under the civil monetary penalties law that prohibit inducements to program beneficiaries. And program beneficiaries are federal health care program beneficiaries, so Medicare and Medicaid patients. So what's the big deal? Do we want these people to get the needed services? We do. But the problem is that if you're waiving these inducements around, these patients might be getting unnecessary services. So the official reason from the OIG, from their bulletin on offering gifts and other inducements to beneficiaries is as follows. Offering valuable gifts to beneficiaries to influence their choice of a Medicare or Medicaid provider raises quality and cost concerns. Providers may have an economic incentive to offset the additional costs attributable to the giveaway by providing unnecessary services or by substituting cheaper or lower quality services. The use of giveaways to attract business also favors large providers with greater financial resources for such activities, disadvantaging smaller providers and business. The unofficial reason, really, is that inducing business increases utilization and costs to Medicare and Medicaid. So the government came out with a statute that says you cannot offer or transfer remuneration to Medicare or state program beneficiaries if the person knows or should know that the remuneration is likely to influence the beneficiaries to order or receive items or services payable by federal or state programs from a particular provider. You can't be offering freebies to your Medicare and Medicaid patients to bring you more business unless you structure the deal to fit within a particular exception, or these penalties that we've talked about are going to apply. And this prohibition applies if you knew or should have known that remuneration is likely to induce Medicare or Medicaid business. There is no specific intent required. You don't necessarily have to intend that the inducement was to get that patient's business. It's really a more general test. Is it likely to induce? And remuneration is defined as anything of value, including but not limited to waiver of copays and deductibles unless you satisfy certain conditions, and items or services for free or less than fair market value unless you satisfy certain conditions. The definition of remuneration is pretty broad, but there are some exceptions. And then the October 3rd proposed rule that came out actually adds or seeks to amend that a bit. So remuneration does not include waivers or copays based on financial need or after failed collection efforts if conditions are met, and keep that in mind, there are conditions, items or services if there is financial need and conditions are met, incentives to promote delivery of preventive care, payments meeting anti-kickback statute safe harbors, retailer coupons, rebates or rewards offered to the public, any other remuneration that promotes access to care and poses a low risk of harm to patient and federal health care programs. That's kind of a catch-all. And certain other situations. So the Civil Monetary Penalties law says that these things do not constitute remuneration, so it would not trigger that prohibition against inducements to program beneficiaries. So let's kind of go through these exceptions. So for free or discounted items or services, you may offer free or discounted items to beneficiaries if the remuneration is not likely to influence the beneficiary to order or receive items or services payable by federal or state health care programs. The problem is this likely language. It's a little tough, so how does it work? Here, if you look at that OIG bulletin on offering gifts and inducements to beneficiaries, the OIG has said if you are offering items or services of low value, and low value has been the OIG has come out and said that low value is each item or service is less than $10 and the aggregate is less than $50 per patient per year. So you definitely need to be tracking this if you're doing this. So the OIG has said if you're offering items or services of low value, you do not necessarily violate the Civil Monetary Penalties law. There's no regulation on this, but the OIG has confirmed it is their position, and you'll find that in their bulletin. Some additional exceptions, you may offer items to beneficiaries if it's not remuneration. If you make a good faith determination that the beneficiary has financial need, if the item or service is not offered as part of any advertisement or solicitation, if the item or service is not tied to provision of other federal health care program business, and if the item or service is reasonably connected with the medical care of the beneficiary. And so you can't say, in order to receive this benefit, you need to come back and get this additional benefit, or you need to participate in this additional program. But if you can tick off those factors on the screen, then you may offer items or services free or discounted to program beneficiaries. You may offer items that fit within an anti-kickback safe harbor. So if you, unfortunately, there's not that many safe harbors that are going to apply in these instances. The discount safe harbor is probably the only one, but it's pretty hard to satisfy, so it's probably not going to give you a lot of relief here for free or discounted items or services. Also, an exception is item or service that promotes access to care and poses a low risk of harm to patients or a federal program. This is pretty broad. Came out under the Affordable Care Act. The proposed rule that I'm going to talk about briefly that came out in October touches on that. There have been some advisory opinions coming out on this. In Advisory Opinion 1116, the OIG concluded it would not seek sanctions based on a nonprofit entity's provision of transportation, lodging, and meal assistance to patients, where, among other things, the program was not advertised in advance, the costs weren't claimed on the cost report, and a public benefit was actually offered through the program. But keep in mind that advisory opinions are not binding on anyone other than the parties to the advisory opinion. You can't really rely on them, but you can use them as guidance. So we do that a lot. Another exception, you can give incentives to promote certain types of preventive care payable by Medicare or a state program if, and it's pretty specific, the prenatal service or a postnatal well baby visit or a service described in the U.S. Preventive Services Task Force Guide to Clinical Preventive Services. And you can find that guide online and just check and see. If it's not tied directly or indirectly to the provision of other services payable by Medicare or a state program, if it's not a cash instrument or if it's not convertible to cash, and if the value of the inducement is not disproportionately large in relation to the value of the preventive care service or future health care costs that will be prevented. So here's something that comes up a fair amount. The OIG has approved certain free screening services or tests where it's not conditioned on the use of any items or services from any particular provider, where the patient is not directed to any particular provider, where the patient is not offered any special discounts or follow-up services. And if the test shows abnormal results, the visitor is advised to see his or her own healthcare professional. Of course, the first question you have to ask yourselves when looking at if you're going to offer free screening services or tests is this likely to induce the Medicare or Medicaid beneficiary to receive services from a particular provider? And then go through the factors there. So this is where, these are situations where the OIG has approved. And again, as I said before, advisory opinions, while very helpful, are only binding on the parties to the advisory opinion itself. Another thing, another situation we see come up is offering free transportation. The OIG has approved free transportation programs where, among other things, the program was open to all eligible patients and not selectively limited to targeted beneficiary populations, where the type of transportation is reasonable. You can't send limos, you can't send the helicopter to go pick up the patients, where the travel is local to physician's office, so maybe not cross state lines unless there's unless that's kind of your area. Public transportation and parking is limited. So if there's some sort of justification like that for the program, that's going to help your case. And then where the cost of a program would not be claimed on cost reports or shifted to a federal program. So you can't be making Medicare or Medicaid pick up the cost of your program. And then you can see the advisory opinion 11-2 is the one that addresses gifts to beneficiaries and transportation programs. Again, advisory opinion is not binding, but they do provide helpful guidance. Additionally, an issue that comes up is for free and discounted items or services provided by a third party. So they're not provided by the provider, but by some third party. And that's okay, but the Civil Monetary Penalties Law does not prohibit an independent entity like a charity from providing free or discounted items or services to beneficiaries. But you need to make sure that the independent entity makes an independent determination of need. It's not your determination of the need, it's the independent entity's independent determination of need. And the beneficiary's receipt of remuneration does not depend directly or indirectly on the beneficiary's use of a particular provider. Remember, the Civil Monetary Penalties Law is not on an island all by itself. There are other laws that you have to consider. For example, if the beneficiary is also a physician or a physician's family member, you have to look to see if this could violate the Stark Law, unless it's structured to fit within the Stark exception. If the beneficiary is potentially a referral source for a federal program business, you're going to need to look at the anti-kickback statute, because if one purpose is to induce or reward referrals for federal health care program business, you need to structure that to fit within an anti-kickback statute safe harbor in order to be safe. And then for private pay patients, you need to look at state laws prohibiting kickbacks. There are state laws out there that are broader than the Civil Monetary Penalties Law and the anti-kickback statute, and the laws prohibiting, state laws prohibiting kickbacks may apply to any patient regardless of payer type. Okay, so that was about free or discounted items or services. What about waiving or discounting copays and deductibles? This comes up quite a bit. So what is the big deal? Medicare typically pays 80% of the reasonable charge, which is based on the provider's customary and actual charges. A provider who routinely waives Medicare copayments or deductibles is actually misstating the actual charges. So, for example, say service costs $100. With the 20% cost sharing of Medicare, Medicare is going to pay $80. If you waive that cost sharing, the actual cost, Medicare argues, is $80, not $100. So instead of paying 20% of $100, the patient should be paying 20% of $80 or $16, and then Medicare argues that they should pay only $64. So if you are routinely waiving copays or deductibles, you are misstating your actual charges. If patients, and the reason, this is the reason that the OIG gives, if patients are required to pay a portion of their care, they will be better health care consumers and select items or services because they are medically needed rather than simply because they're free. Ultimately, if Medicare pays more for an item or service than it should, or if it pays for unnecessary items or services, there are less Medicare funds available to pay for truly needed services. So the government has identified certain red flags where you might get into trouble. So if you see language like this, that should raise some red flags and you need to look at it more closely. So advertising no copays or deductibles. Language like Medicare accepted as payment in full, or no out-of-pocket expenses, or insurance-only billing, that's gonna raise a red flag and probably be an issue. And then also look to see if there's routine use of financial hardship forms without a good faith attempt to collect or without doing determinations of financial need. And then also a red flag is collection of copays only if the patient has Medigap coverage. You can, in certain circumstances, waive copays or deductibles. You may waive or discount Medicare copayments or deductibles if they're not offered as part of any advertisement or solicitation, if you do not routinely waive copays or deductibles, and you waive or discount after you make a good faith determination that the beneficiary is in financial need, or you're unable to collect after reasonable collection efforts. You should look at your charity care policy and make sure it incorporates these kinds of factors in making your determination. So document factors such as local cost of living, patient's income, assets and expenses, patient's family size, scope and extent of bills. So that determination, if you go through that determination, make sure you document it and also make sure that it is in your charity care policy. Now there is a separate exception that allows you to waive or discount copays and deductibles if you fit within an anti-kickback statute safe harbor, but this is pretty limited. So only if it's hospital inpatient stay paid under the prospective payment system, waived amounts cannot be claimed as bad debt or shifted to any other payers. It's got to be offered without regard to the reason for admission, length of stay, or DRG, and the waiver may not be made as part of any agreement with a third-party payer with limited exceptions. Also an exception, but it's pretty limited, is federal, the FQHCs or other healthcare facilities under any public health services grant. Again, the civil monetary penalty law does not exist by itself out there. You've got to think about other laws when you are dealing with these issues. So unless you can fit within an exception, you need to be concerned about if the physician or family member of the physician, or if you're waiving copays for a physician or a family member of the physician, that could violate the Stark law unless you fit it within a Stark exception. If you're waiving copays or deductibles from a potential referral source, you've got to think about the anti-kickback statute if one purpose is to induce referrals for federal health care program business, unless you can fit it within a safe harbor. And then for private pay patients, you need to look at your managed care contracts. Most are going to prohibit you from waiving or discounting copays or deductibles, so look at those. You could be in breach of contract if you're doing that routinely. And then take a look at state laws prohibiting kickbacks, rebates, or fee splitting. In Idaho, where I'm at, Idaho has a statute that prohibits the regular practice of waiving copays and deductibles. So check the state law wherever you are. So we talked about waiving copays and deductibles and offering free or discounted items or services. What about prompt pay discounts? The anti-kickback safe harbor for waivers of copays may apply if a hospital inpatient or a federally qualified health center, or FQHC, OIG has approved prompt pay discounts if the amount of the discount relates to avoided collection costs, if it's offered to all patients for all services without regard to patient's reason for admission, length of stay, or DRG, so you're not cherry picking. You're not offering as an inducement for more business, and you're not cherry picking. It's not advertised, and it's not. And you need to notify your private payers of the program because the contract might not allow you to do this. So take a look, and then so long as the costs are not passed to Medicare, Medicaid, or other payers. Again, beware the managed care contracts because your contracts might not allow this. So everything we just talked about, they were exceptions to or exclusions from civil monetary penalties, definition of remuneration. On October 3rd, the proposed rule came out seeking to amend the definition of remuneration by excluding the following: copayment reductions for certain hospital outpatient department services, certain remuneration that poses a low risk of harm and promotes access to care, coupons, rebates, other retailer reward programs that meet specified requirements, certain remuneration for financially needy individuals, and copayment waivers for the first fill of generic drugs. So you'll see the citation there for the proposed rule. Take a look at that. Comments were due December 2nd. I haven't heard anything since then, but didn't expect to this quickly. So. All right, so the civil monetary penalties law also prohibits payments to reduce or limit services. What's the big deal about that? Aren't we into efficient healthcare? Don't we want to reduce or limit services? Well, yeah, but when the government changed to the prospective payment system, DRGs, the payment for hospital episode of care was capped despite costs involved in care, and the government was concerned that hospitals would create incentives to reduce costs by reducing or limiting services. And as you see there, Congress said, we must not tolerate hospitals paying physicians to reduce or limit services to the elderly. So there's a provision in the civil monetary penalties law that states a hospital or CAW, and so this only applies to hospitals or CAWs, a hospital or CAW cannot knowingly make a payment directly or indirectly to a physician as an inducement to reduce or limit services provided to Medicare or Medicaid beneficiaries who are under the direct care of the physician. The physician cannot knowingly accept such a payment. The penalties for this: $2,000 for each individual with respect to whom payment is made, and any other penalty allowed by law. So this provision is pretty broad. According to the OIG, any hospital incentive plan that encourages physicians through payments to reduce or limit clinical services directly or indirectly violates the statute. The payment need not be tied to actual diminution in care so long as the hospital knows that the payment may influence the physician to reduce or limit services. And there's no requirement that the payment be tied to a specific patient or a reduction in medically necessary care. And that's from the OIG Bulletin on Gainsharing arrangements. Now, there is the proposed rule in October did discuss Gainsharing arrangements. I'll talk about that in a bit. This does not apply to Medicare or Medicaid risk-based managed care contracts and Medicare Advantage plans, which are governed by a different statute. The net effect: this provision generally prohibits gain-sharing arrangements. So what are gain-sharing arrangements? They're arrangements in which a hospital gives a physician a percentage or share of any reduction in the hospital's cost for patient care attributable in part to the physician's efforts, i.e. the physician shares in cost savings. The OIG is concerned about a variety of things, stinting on patient care, cherry-picking healthy patients, and steering the sicker patients to other hospitals that don't have those arrangements, payments to induce referrals, and unfair competition among hospitals. But regardless of the general prohibition, the OIG has periodically approved gain-sharing arrangements and advisory opinions if certain safeguards are included. There are about 8 or 10 advisory opinions out there on this, and most of the approved arrangements have certain protections like this in place. For example, the proposed plan does not adversely affect patient care, and the quality is evaluated by a third party. There's a low risk that the incentive will lead physicians to provide medically inappropriate care. The payments are limited in duration and amount, and the payments are not tied to referrals or other suspect actions. So the general rule, it's illegal, but it has been approved in certain instances. Keep in mind, however, that OIG advisory opinions do not apply to Stark. CMS did propose a Stark exception. It wasn't finalized. Stark's governed by CMS. There's no exception under Stark except for ACOs, which we'll talk about in a little bit. And the ACO waiver was recently extended through November 2nd of this year, so I'll talk about that in a minute. The proposed rule on gain sharing purports to codify the gain sharing provision of the civil monetary penalties rule, and in the proposed rule they sought comments on specific areas of concern, including the following. Should a hospital's decision to standardize certain items be deemed to constitute reducing or limiting care? Should a hospital's decision to rely on protocols based on objective quality metrics for certain procedures ever be deemed to constitute reducing or limiting care? Should a hospital desiring to standardize items or processes as part of a gain-sharing program be required to establish certain thresholds based on historical experience or clinical protocols beyond which participating physicians could not share in cost savings? So they asked some pretty specific questions, and comments were due just last month on that. There are also provisions in the civil monetary penalties law that apply to excluded entities. As you know, HHS may exclude individuals and entities from participating in federal health care programs for a number of things. If they've been convicted of fraud or abuse or many other offenses, you can see where the mandatory exclusions are and the permissive exclusions are. You can find those in the federal regulations. States are required to exclude from Medicaid any person who has been excluded from federal programs. And then, this is really important, the exclusion continues until the OIG reinstates the entity or withdraws the exclusion. You've got to apply for reinstatement. There is no automatic reinstatement. You've got to apply, so don't forget this. If you've ever been excluded and you want to get reinstated, you have to apply. If you are excluded, you cannot order or prescribe an item or service if you know or should know that a claim for such item or service will be made under a federal health care program. Do not order services or prescribe if you know someone is going to submit a claim to the government. The penalties are $10,000 per item or service, treble damages, repayment of amounts paid. Employers cannot knowingly present or cause to be presented a claim to a federal or state program that is for an item or service furnished by an excluded person. Employers or anyone else cannot knowingly do this. So the penalty for that, again, $10,000 per item or services, treble damages, exclusion, and there's also criminal sanctions for this one. In addition, you cannot hire or contract with an excluded entity or arrange for an excluded entity to provide items or services payable by federal healthcare programs if you knew or should have known of the exclusion. And then you can read the penalties there. So a little bit more about that. According to the OIG, the prohibition against contracting with excluded individuals applies not just to providers, but includes administrative and management functions necessary to providing clinical items and services. This applies to employees, contractors, temp personnel. It applies even to volunteers, and it applies to persons paid by third parties. You cannot use federal payments to cover an excluded individual's salary, expenses, or fringe benefits. And take a look at the OIG Bulletin, Effective Exclusion from the Program, and then there was an update, I believe, in 2013 on the effective exclusion as well. So there is a limited exception here. You may contract with an excluded entity if that excluded entity or person is paid, if the payment of the excluded individual's salary, benefits, and expenses are solely paid from non-federal funds. And then if services furnished by the excluded individual relate solely to non-federal program patients. So this is really hard to do. Bottom line, if you're excluded, that's the death knell for your participation in federal health care programs. In addition, an excluded person cannot retain a direct or indirect ownership or control interest in an entity that is participating in a federal or state program if the person knows or should know of the action constituting the basis for the exclusion, or be an officer or managing employee of such entity. Penalties for that, $10,000 per day that their relationship continues. And you could also get hit with treble damages and then repayment of amounts paid. Persons who own or manage excluded entity and entities that are owned or controlled by excluded persons may be excluded. So Medicare, Medicaid, or other federal programs will not pay a claim if the person knew or should have known of the exclusion. There is a limited exception for certain emergency services. But what does knew or should have known mean? What is knowledge? You have to have actual knowledge of the exclusion or sufficient facts that you should have known of the exclusion. For instance, if you're notified of HHS of the exclusion, for example, in response to a claim, whereas they give you, in response to the claim, they say, we're going to pay this once, but take a look at this guy's excluded. The prohibition will take effect a certain number of days after the notice is mailed. And then also there is available online the list of excluded individuals or entities, the LEIE. It is a database that is very easily accessible, and so the government expects you to check it. You have an affirmative duty to check it. So knowledge, because that LEIE is out there, you knew or should have known that a person you've contracted with or employed was excluded. Talk a little bit more about the LEIE. Providers and contracting entities have an affirmative duty, like I said, to check the program exclusion status of individuals and entities prior to entering into employment or contractual relationships, or run the risk of civil monetary penalties liability if they fail to do so. So you're going to want to check the LEIE before hiring or contracting with entities, employees, contractors, vendors, medical staff. Check it for the volunteer list that comes in. And then you're going to want to check the LEIE periodically once those people are hired or contracted with. Check it periodically to determine if they've been excluded since you last checked it. Employees, providers, vendors, medical staff members, ordering providers, maybe everybody else. The LEIE is updated monthly online. And I apologize that this is not updated. There was a special advisory bulletin on the effective exclusion in 2013. I tried to add this, but I'm not sure why I didn't make it onto this slide. Where the OIG said that screening monthly best minimizes potential overpayment and civil monetary penalties liability. So there was a CMS Medicaid letter that went out in 2009 where they told Medicaid to check the LEIE monthly, and then this OIG Special Advisory Bulletin on the Effective Exclusion from May 8, 2013, where the OIG recommends checking it monthly. So I would say you should check it monthly. This is where you can check it. You probably have already been to this, but you can check it pretty easily. You just input the name of the person or the entity and search, or you can download the whole database to run searches on your own computer. And because this exists, the government is not going to give you much of an argument on that knew or should have known language. So the CMP also states that if you know of an overpayment, you must report and return overpayment within 60 days per the False Claims Act requirements. An overpayment is any payment to which you're not entitled. So you've got to return it within 60 days. Or be subject to penalties, civil monetary penalties, law penalties, and also you may also be subject to False Claims Act penalties as well. There are also penalties for failing to grant the government access. The civil monetary penalties law also prohibits you from failing to grant access to the OIG. You cannot fail to grant timely access upon reasonable request to the OIG for purposes of audits, investigations, evaluations, or other statutory functions of the OIG. Penalties for that, $15,000 for each day that you fail to grant them access, and you can also get excluded for that. Okay, so we were talking about gain sharing, and I mentioned that there is a waiver for accountable care organizations to do gain sharing. So the Medicare Shared Savings Program promotes actions that might be prohibited under the Civil Monetary Penalties Law. For example, inducing reduced costs to Medicare by sharing cost savings with ACO providers, and inducing beneficiaries to receive services from ACO members. So CMS OIG issued interim rules waiving the Civil Monetary Penalties Law, the Anti-Kickback Statute, and STARC for ACOs participating. There are different waivers depending on the situation. The ACO pre-participation waiver, the ACO participation waiver, the shared savings distribution waiver, compliance with STARC, Anti-Kickback Statute, and gain sharing Civil Monetary Penalties waiver, and patient incentives waiver. Each waiver requires compliance with certain conditions, so you're going to want to look at those. This waiver was extended, as I said earlier, through November of this year. And in the interest of time, I'm not going to go through each one of these. Each has certain criteria that has to be satisfied, as you'll see in the slides. Bottom line, if you're an ACO, you have additional flexibility, and that additional flexibility has been extended through November of this year. Okay, OIG guidance. So the government has issued a fair amount of guidance. They've published advisory opinions that cover such things as free screenings or tests, as we talked about, gift cards to patients to respond to patient complaints or promote wellness screenings, waiving copays or deductibles, prompt pay discounts, gain sharing, rewards cards, coupons, et cetera. So these opinions are fact-specific, and they only apply to the parties to that specific advisory opinion. But like I said, they do offer some good guidance. So if you have any of these issues, you can go to the OIG's website, and they have all of their advisory opinions cataloged. And it's kind of nice, and you can even search through them for specific facts that you may need to look at. They've also issued some fraud alerts and bulletins. Offering gifts or inducements to beneficiaries, routine waiver of copayments and deductibles, the effective exclusion from participation in federal health care programs. That one has also been updated, so you're going to want to look at the 1999 one, and then you're also going to want to look at the 2013 one, and I apologize if that's not on the list. But then also you're going to want to look at the gain sharing arrangements and civil monetary penalties for hospital payments to physicians to reduce or limit services to beneficiaries. And then always be aware of changes in the law. Here's where you can go to check out those special fraud alerts and bulletins on the OIG website. I mean, they really do have a pretty good website for finding all of this information. They don't want you to violate the law. Okay, so say you have a potential civil monetary penalties law problem. What happens? If you think you have a CMPL problem, don't ignore it or attempt to sweep it under the rug. Remember the False Claims Act penalties. Don't submit claims to Medicare or Medicaid until the situation is resolved. If possible, stop the suspect conduct until questions are resolved. Evaluate the situation carefully. You're going to want to confirm the facts. Review the civil monetary penalties law for possible exceptions. Check for advisory opinions, check the OIG bulletins, and then as necessary, seek qualified expert advice. And if necessary, revise the arrangement going forward so you don't find yourself in this situation again. And then, if necessary, repay CMS. So, repayment obligation. You've got to report and repay overpayment within 60 days under the False Claims Act. And an overpayment is any payment to which you're not entitled, including a payment in violation of the anti-kickback statute. For a knowing failure to repay, the violation is going to be $5,500 to $11,000 per claim, and then treble damages. And then a violation of the civil monetary penalties law is $10,000 per claim. So it adds up. Another alternative, you may want to go into the OIG Self-Disclosure Protocol. It's a completely voluntary program to self-report violations. And if you engage in good faith, the government has said they'll likely reduce penalties. So there is a benefit here. Generally, the self-disclosure protocol applies to violations that involve actual knowledge, reckless disregard, deliberate ignorance, and then as long as there are no honest mistakes or as long as there are no honest mistakes or errors, the government may, or if they are honest mistakes or errors, the government has said they'll likely reduce penalties. So you got to weigh the risks and the benefits. There are some benefits, as I said, may reduce penalties, and that's a may, they might not. Probably no corporate integrity agreement, and then the risks, there are some risks. The OIG may broaden the investigation, and they may report to other government agencies as well. So participation is kind of burdensome, and so, I mean, you've got to really just weigh the risks and benefits here. So here's an example. If you have an excluded employee, if you self-report, the OIG will require repayment, and that's usually some kind of, it's a mathematical formula. The salary and benefits of the excluded individual times Medicare and Medicaid percent times the multiplier of 1 to 2%, and then they'll come up with the repayment amount. But if you don't report, things will go badly if you're caught. If say this employee subsequently reports to the OIG that they were excluded and you were submitting claims to the government, the OIG will obtain the excluded individual's work history and then go after you. And at that point, it's too late to self-report and get the benefit of the self-disclosure protocol. So you're going to be subject to penalties. The OIG website has information on self-disclosure. If you have a serious civil monetary penalties issue, you should seriously consider doing report and repay or doing the voluntary self-disclosure protocol. And just you can get more information from this website, or you can get more information by calling us. Action items. Here's what you should do now after we get off the phone. Review arrangements with program beneficiaries. If you've got arrangements where you're offering free items or services such as screening, if you've got arrangements where you're waiving copays or deductibles, take a look at those and make sure you're in compliance with the civil monetary penalties law and the other laws that we've discussed. If you have a financial need policy, get that out and see if it complies. If you don't have a financial need policy, get one. And then if you've got marketing or advertising programs, take a look at those, and then prompt pay discounts, take a look at those as well. You're also going to want to review financial arrangements with physicians to ensure there are no inducements to limit services. So if you've got cost savings programs, bonuses or compensation tied to cost savings, any type of gain sharing like we discussed, you're going to want to review those to make sure they're in compliance. And then you're also going to want to establish a process for monitoring. Make sure you are checking for excluded providers. And like I said before, you're going to want to do this at the beginning for new hires and new contracts. You're going to want to do it during medical staff credentialing. You're going to want to do it for ordering physicians, and you're going to want to do periodic checks of all employees and contractors. So once you do it at the beginning, you're going to want to keep doing that. Everyone is suggesting monthly because the LEIE is updated monthly, and the government is not going to say that you didn't know. You should have known because you should have checked the LEIE. It's pretty easy to do. You're also going to want to require contractors to confirm that they are not excluded. And you might want to amend your contracts to require the same. So on provider contracts, temp agency contracts, vendor contractors, it might be nice to throw in a representation and warranty that they and any of their employees, if they're a vendor or an agency, have not been excluded from any government health care program. And in addition to that representation and warranty you want to throw in there, you might also want to throw in an indemnification provision where they indemnify you if, in fact, they have any employees or contracts with excluded entities or individuals. So that's a good thing to do, is take a look at your contracts and add those provisions. You also want to ensure that your compliance policies address the civil monetary penalties law. And again, even though the Supplemental Hospital Compliance Program guidance only applies to hospitals, it's got some good stuff in it. And then you also want to train key personnel regarding civil monetary penalties law compliance. So administration, compliance officers and committees, human resources employees, physician relations and medical staff officers, marketing and public relations staff especially, because they always come up with great ideas, but their great ideas might actually be in violation of the law. And then governing board members should also be trained on it. Purchasing staff should also be trained on it, and accounts payable as well. And of course, you always want to document this training. Again, if you think you have a problem, see everything that we discussed earlier. So, additional resources. Like I said, the OIG compliance website is a great resource. They have, there's the Compliance 101 series, and then the OIG Compliance Program Guidance, Supplemental Guidance for Hospitals, Compliance Program Guidance for Physicians as well. I always suggest looking at advisory opinions because they have such helpful information. Special fraud alerts, fraud bulletins, letters, other materials. The OIG website is just a really good place to start if you're not sure where to start. Additional resources, if you look at our Holland and Hart website, the Health Law Basics monthly webinar series, all of that is online. You can download them, listen to them, use them as training if you like. For our future webinars, as I mentioned at the beginning, next week is going to be responding to noncompliance and repayments by my learned colleague Kelly McIntosh, and that will be on the 29th. And you should, if you signed up for this one, get the reminder for that one as well. And then always check our health law blog because we are keeping up on top of the laws and sending out client alerts as well. So if you want to get on that list, just let us know. Looks like our time is up, so if you have any questions based on this information, go ahead and either submit it via the chat line or I think now that everything's going to be closing out, you can just email me directly at hollandandhart.com or hollandhart.com. So thank you very much, and we will speak to you again next week. Thanks.